All right. Welcome back. I know this is a weird angle, but I'm having trouble getting set up tonight. And now it's too dark to go outside and do this on my patio. So, I'm in my den. All right, jumping into chapter 5. This is not one that, it is tested, but not as heavily as the other chapters for this module. And it's not something that I practice regularly, or really even that my firm practices regularly, because it's such a specialized area of the law that when somebody calls with questions dealing with copyright, trademark, patent, we send them to another attorney in town that really holds herself out to specialize in this. So I'll teach you a little bit of what limited knowledge I have, but also what I've learned from this class. So, going right along, intellectual property. That is any property resulting from intellectual, creative processes. So it's property that results from intellectual and creative process. This is the apps on your phone. This is movies, this is music, this is songs, this is books. It's your intellectual, your creative work that is property. It's considered property and it gets protection. So there's 3 different types of intellectual property and the protections that we're going to talk about. The first one's trademark. So a trademark is a distinctive word, symbol, sound, or design. A word, symbol, sound, or design that identifies the manufacturer as the source of those goods and distinguishes, that's the next blank, distinguishes its products from those that are made or sold by others. Word, symbol, sound, or design that's going to distinguish the manufacturer from other people. Nike has their check. They also have the word Nike. But that's what distinguishes it from Reebok, from Asics, from New Balance. That is trademarked. And that's what distinguishes it from all of the others. Number 1, in addition to names, trademarks can also include catchy phrases and shapes. Now, a circle, you're not going to get a trademark for that. But there are certain shapes that if it's distinctive enough to distinguish your company, you can try to get a trademark on it. Catchy phrases, think about it. Nike, what's theirs? Just do it. Just do it. When you hear that, you think of Nike. It's trademarked, and nobody else can advertise their product with that catchy phrase of just do it. So catchy phrases and shapes are going to be just as protected. Number 2, protection is available. So trademark protection is available at the state and federal levels. All right, so you can get state protection. You can go bigger than that and get federal protection of your trademark. So point A under there, protection at the federal level is provided by the Lanham Act of 1946. Lanham is Lanham. The Lanham Act of 1946. That's what gives you that federal trademark protection. And under the Lanham Act, when you are suing because of a trademark violation under federal protection under the Lanham Act, little point 1 there. The Lanham Act protects manufacturers from losing business because your trademark's been infringed. So if you're going to sue under the Lanham Act, you're going to be saying that a manufacturer, that you as a manufacturer, you've lost business because your trademark, your federally recognized trademark has been infringed on. Somebody has used it without your permission, and you've lost business because of that. In line with that is point B, trademark dilution. Now, when you dilute something, it means you kind of weaken it. Think of diluting something, a liquid. You've weakened it. So under the theory of trademark dilution, that is the unauthorized use of a distinctive and famous mark in a way that impairs the mark's distinctiveness or harms its reputation. All right, so the unauthorized use of a distinctive and famous mark in a way that impairs the mark's distinctiveness or harms its reputation. knockoffs. All right, that's why you can't have knockoffs legally, because you're diluting. What if it's, you've got a real Reebok shoe and then you've got a knockoff? Well, if it's harming its reputation because it's a terrible made shoe, and this one that's actually made by Reebok is really good, then they may claim trademark dilution, because you can't use something that's already trademarked. So, in line with the protections that you can get at the state and the federal level, number 3, trademarks can be registered with the state or the federal government. So we can register it if we plan on just staying within. If we're a mom and pop shop, we're just going to be here in Kentucky. We're not going to be, advertising and shipping all over the world or all over the country. We may just want state protection. If we're going nationally, we may want the federal protection, though. So you can register them with the state or the federal government. The symbol for a trademark, if something has been trademarked, you're going to see one of two things out to the side of it. Either a little R with a circle around it, or a little TM. So when you look next time at the Nike symbol or the phrase "just do it," look for that little symbol to the side of it that tells you this is trademarked, you cannot replicate it. So it's either the little R with a circle around it or the little TM. All right, so what is trademark infringement? That's number 5. Trademark infringement is when the trademark is copied to a substantial degree or used in its entirety by another, either intentionally or unintentionally, okay? If something is trademarked, oops, I didn't mean to, you've still infringed on that trademark if you copy it or you use it, okay? So trademark infringement when the trademark's copied to a substantial degree or used in its entirety by another, either intentionally or unintentionally. So point A, this is kind of a hard thing, and you always kind of run the risk of being sued on this. Trademark does not have to be registered in order to file suit. Now, obviously, if it's registered, that's going to provide better proof of who had it first. But you don't have to have your trademark registered in order to file suit and allege that somebody is copying and infringing on your trademark. Now, that kind of can get complicated, because how do you know everything out there? Well, arguably, you can do an internet search. You can do your best to see if anybody else is already using that word, that symbol, that sound, that design. But you can still be sued even if it's not registered, but registering it is the best way to ensure that you have the protection. I was here first, okay? All right, so trademark, word, symbol, sound, design. On the other hand, another type of intellectual property is a patent. P-A-T-E-N-T, a patent. That is a grant from the government that gives an inventor the exclusive right to make, use, and sell an invention for a period of time. All right, so when we talk about patent, we're talking about an invention. All right, you're getting the government to say that you have the exclusive right to what it is that you've invented. All right, so number 1, the applicant, in order to get the patent, must demonstrate that the invention, the discovery, the process, the design, whatever it is novel, meaning new, N-O-V-E-L, it's novel. It's useful. We're not just going to patent anything and everything. It has to be useful and not obvious in light of current technology. Okay, so it has to be new or novel, useful, and not obvious in order for the government to give you a patent for your invention. And this provides you the protection, if you get the patent, under the Patent Act. Original, right? So the protection that's afforded is under the Patent Act. All right, number 2, I'm talking about a lot of different acts. Now, when I say acts, these are laws, okay? Laws that have been passed, but they've been named something. So number 2, the America Invents Act. The America Invents Act. This law says, the first person to file an application for a patent will receive the protection. Hence why people move very, 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 very quickly when they are trying to invent something, because they don't want somebody to beat them to the punch and getting it patented and then all their work is for naught. All right, so under the America Invents Act, the first person to file the application for the patent is going to get the protection. So number 3, I want you to take a look further, and we'll discuss this in class when we're in person, but take a look at the in-dash navigation system and the Apple versus Samsung. It's on page 149 of your textbook. I don't know that your online copy that's in Blackboard has page numbers, but look in this section. You will find the little section that's kind of singled out about the in-dash navigation system in Apple versus Samsung, and how their ability to get patents and how many different things within your navigation system, within your Apple phone, within your Samsung phone, how many of them are patented. It's insane. But take a look at that. We'll talk about more of that in class. Okay, so you've got trademarks, you've got patents, and third, you have a copyright. If something's copyrighted, what does that mean? That means it is an intangible property. Intangible property right granted by federal statute to the author or originator of literary or artistic productions. So formal. All right, an intangible property right that's granted by federal statute to the author or originator of literary or artistic productions. All right, this is your things that can be copyrighted, your books, your movies, your art, your architectural plans, your music, your videos. Those are literary or artistic works, and you want to try to get those copyrighted for protection so they can't be copied. Number 1, copyright is governed by the 1976 Copyright Act. There's another law for you. It's governed by the 1976 Copyright Act. All right, number 2, the symbol for a copyright, if something is copyrighted, look in a book the next time you have one open. You'll see a C with a circle around it, and usually a year followed by that, what year it was copyrighted. Okay, so a C with a little circle around it. That's the symbol for a copyright. What are they protected against? What's a copyright protect you against? Number 3, copyright owners are generally protected against the following. Number 1, reproduction of the work. Reproduction of the work. Number 2, development of derivative works, so sequels. Development of something that stems from your work. Number 3, distribution of the work. You get a say in where it is copied or reproduced, and then where it's distributed, and you also get rights to that and money. So reproduction, development, distribution, and public display of the work. All right, where is it advertised? What does that display look like? Reproduction, development, distribution, and public display. So what is protected? What's copyrightable? All right, I'm going to give you a list, and I'll go slow. Books, records, films, artworks, architectural plans, menus, music videos, product packaging, and computer software. That's a non-exclusive list of some things that are copyrightable. What's protected? Books, records, films, artworks, architectural plans, menus, music videos, product packaging, computer software. The main point to remember under that is little number 1. The work, in order to be protected, in order to be copyrightable, it must be fixed in a durable medium, something that can be copied, a song, a book, a film, a menu, something that's in a durable medium that somebody can copy, something that we can actually give protection to to avoid it being reproduced in violation of the copyright laws. All right? Number 5, the protection is automatic. It's automatic. If somebody created it, somebody owns it. So registration isn't going to be required. Now, again, even though you have the automatic protection, if I created it, I own it. If somebody else argues that they created it and they own it and they have it copyrighted, obviously that's going to be better proof of when they developed it, because here's the date of when it was copyrighted. Did mine come before? Did mine come after? Registering it, even though you don't have to do that to get the protection, registering it gives you better proof of when it became yours, when it was created, because then it's automatically protected. All right. Last but not least, on patents, something to keep in mind is the first sale doctrine. The first sale doctrine. This means that the owner of a particular item that is copyrighted can, without the authority of the copyright owners, sell or otherwise dispose of it. All right. So the owner of a particular item that is copyrighted can, without the authority of the copyright owner, sell or otherwise dispose of it. This protects yard sale goers. All right, I can sell my old Taylor Swift CD at a yard sale without having to contact Taylor Swift and make sure that it's okay for me to do that. The first sale doctrine basically says the copyright, the person who owns the copyright, they're protected on that first sale. After that, what people do with it, so long as they're not reproducing it, when you burn CDs, technically you shouldn't be doing that. I don't even know if you guys know what that is. We used to do that all the time. But, as long as you're not reproducing it, developing sequels from it, distributing it, anything like that, you can sell it after that first sale to you is made without having to worry that you're violating any kind of copyright laws. So, in a nutshell, if you have an idea, you have a creation, you have an invention, talk to an attorney, talk to an intellectual property attorney, and see how to best protect that. See how expensive it would be to, and I don't think it would be much, to protect it in the event that somebody else thinks they came up with it in the future. So pretty interesting stuff. All right, I'll see you guys in class.